to see if the seller's paying anything and how much.
Okay. Hi guys, sorry I was a little bit delayed. I just got off of a forms training. We're going to talk about all of these things, but because we have a short time frame and a lot of forms to go over, I'm going to ask you to do two things. Hold your questions until the end and put them in the chat. So that way I have them and I can address them as they're coming in. These forms are already active. If you've noticed, you've been into zip forms, or if you use another like dot loop, they are there, they are updated. I have the red line versions. We're gonna go through the red line versions. There's a couple of points where I will reference back to Ravi because there are broker specific items that he needs to address. So again, I thank you for being here. It's an interesting time to be in the real estate business, and we are going to address as many of these things as we can right now. There probably will continue to be some changes as we get closer to the settlement, and there will be continuing questions being answered. There's an FAQ on Texas Realtors related to these legal issues. You can always go in and check that for updates because as they've done these courses, they've had a lot of questions asked that are going back to Texas Realtors, and they're continuing to publish new answers, okay? All right, let me just pull up these forms.
Just in case if there are agents, new agents that don't know Jennifer. Jennifer Martinez is our on-tour supervisor. She is amazing and she's here to help us. And she told me last week I wanted to give a class on this so she can keep everyone up to date, with these new contracts or new documents going forward. So thank you so much, Jennifer.
Thank you, Robbie. Okay. I'm just going to go through and show you the red line versions. Let me slide this over so I can see this better. Okay. So this is, and you're going to probably hear a lot of people referencing the Texas Realtors numbers, because in every course that I took related to these forms, they were talking about them by number. So this is 1101, the residential real estate listing agreement, exclusive right to sell. Okay, and so obviously there's this little red line here because they've changed the date. They've changed it to revised in 2024. The page one, no changes there. What really has changed is the compensation. So, sorry, let me just stick that phone out of the way so I can focus. Okay. Broker's compensation has been changed. So everything that is in red, that has been removed from this form, and all of the blue are the changes, the additions. So on here, broker's fee with compensation for other broker. Okay, this is authorizing for compensation to another broker, okay, that is bringing the buyer. On here, you're going to have A or B. A is the percentage of the sales price or the flat rate. I will tell you, be prepared to see a lot more flat rates. I've already started encountering them. It's going to be a very interesting couple of months because people that are educated about what is going on in the nation with this lawsuit and are now realizing they have more options than they thought they did, which the reality is they always had the options, they just maybe didn't realize it. They are starting to question about what is going on and what they can do or what they don't have to do. So one of the main things that you need to understand is make sure that you're having this discussion with your seller when you're doing these listing agreements. So this is for, again, percentage of the sales price or a flat fee. B is if you're going to offer a variable rate. So if another Encore agent comes with a buyer, is the seller going to get a discounted percentage or discounted rate for selling that way? Number two, broker's fee without compensation for other broker. So if they are not going to be offering compensation for the other broker, you will use section B here. So that obviously is a big change. Pay attention to this note. Seller paying buyer's expenses. In addition to paying the above broker's fees, a buyer may request a seller to contribute amount towards buyer expenses, such as buyer's broker fees or other closing costs. There is a paragraph 11F that gives the authority regarding such contributions. And again, sellers can do both. They can do one or the other. They can offer nothing. You just need to make sure that you're having those discussions up front. And as we were talking about today in the course that I took, be very careful in the discussions that you're having, and don't tell them that not offering these compensations will definitely reduce their buyer's pool, because you cannot guarantee that. That is not a statement that you want to be made or held accountable for. You can inform them what is going on in their respective market. So for example, if you're listing a home in North McAllen, you can say that I've looked at the transactions taken place, the sales that have happened in the last 3 months, 6 months, whatever time frame you want to refer to, and let them know that X% of these sales offered concessions. X% of these sales were financing FHA. X% of this was going on with this transaction in this area. Those are all facts. You want to make sure that you're armed with facts and not opinions or speculations, okay? So again, that is a note that they're making sure that the seller is aware of. The rest of these, they've just had to change paragraph numbers where they've omitted or added sections. So as you'll see, a lot of it is they're just capitalizing a word to make it stand out more, changing paragraph numbers. Okay. Nothing changes on the listing services. Nothing is changing on the listing content. Cooperation with other brokers has gone away. Everything now is included under the compensation paragraph. Paragraph 8, they are reserving that for future use. So for right now, they are just leaving this open if in the future, before the settlement is actually agreed upon and approved, you need to add something. Judy, could you please mute? Thank you. Okay, this is a section, so intermediary status, non-intermediary status. Again, they have a choice. Do they want to have intermediary status or do they not? Again, they need to understand what this means. So as an intermediary, Encore would be the intermediary, correct? And then you would be appointed as their agent, and there can be an appointment for a buyer's agent, okay? These are all the conversations that you need to get used to having when you're having these presentations and discussions. If you don't understand intermediary status, I highly suggest that you call Robert and or me and get a more detailed understanding of what that means. So confidential information didn't change, broker's authority didn't change. I will tell you, I had an interesting conversation though with a seller this last week where they didn't want to offer FHA or VA. And again, all I can tell them is these are the transactions that are happening in your area. FHA is one of the most common. So if you choose to go that route, you just need to be aware that a lot of the buyers might not be looking at your home. And again, that is a fact. That is not something that I'm giving them an opinion on. Down here under D4, they have changed or added, excuse me, this statement, right? So disseminate information about the property to other brokers and prospective buyers, including offers of compensation to buyer representatives and applicable disclosures or notices that the seller is required to make under law. So they are, again, highlighting that this is an offer of compensation. Everything about commissions has been taken off. It is now being referred to compensation. All right, here we go. Paragraph 11F. This is now the seller has to make this decision. They do or do not authorize the broker to share with other brokers and prospective buyers that they will consider contributing an amount towards buyer's expenses, such as broker fees or other closing costs. Seller is not obligated to pay any specific amount and has sole discretion to negotiate payment of buyer's expenses with buyer under the sales contract. So, in a nutshell, seller can decide today that, yes, I want to offer compensation. And 2 months from now, with whatever reason that they decide to change, right? They can become more educated about what's going on the market. They can become more educated about the settlement agreement and terms. For whatever reason, they can change their mind. And there is an amendment that is created that will address that. But you need to be prepared that these things could start happening. So that is one of the other reasons that we are holding this session. So once the seller is under contract, though, and they have already agreed to either a concession or a compensation for the buyer's agent or both, we need to understand that that has now become a contractual agreement and they are obligated. This is just in the listing agreement. Okay, so again, make sure that they understand when going under contract, that now becomes legally binding. Seller's representations is not changing, additional promises, limitation of liability, none of these things are changing. The majority of what's changing on here was what was already discussed related to compensation. They have removed broker's compensation, or the sharing of compensation between brokers is not fixed. It's worded that way in the other section, further in the compensation section. And again, they just changed all of these numbers. Moving on. Residential real estate listing agreement, exclusive right to lease. As you're going to see, broker's compensation has changed again. So pretty much the exact same thing that we just went over on the exclusive right to sell. So this is the section with compensation for other broker, the percentage of the full month's rent, percentage of all rents, or again, C is if there is going to be a variable rate. And then down here, this one is stating that broker will pay the other broker the following fees. So this is where you would have initially put it out before, that they're willing to pay them half of the 1 month's rent. They're willing to pay them, $300, whatever your client chooses and agrees upon with you, that's where that would go. Section B is if there is a subagent. And the most common example that I can give you here is if you have an agent from another brokerage agree to go to an open house on your listing, then they could now become a subagent. It's not very common that you see this, but that would be the best example of what a subagent is. And then again, brokers fee without compensation for the other broker. So if there's no compensation offered to the other broker, then this is the section that you would fill in. Again, they just changed little things here and there related to paragraph numbers. The same thing on this one. They have removed cooperation with other brokers in paragraph 8 and just changed it to a reserved paragraph if they need to use it in the future. No changes, no changes, no changes, no changes, no changes. One thing that I do want to point out really quickly is you will see it now says broker's printed name. Okay, so on here, your broker is Ravi. It's not the company name, it's Ravi. All right, really quickly, farm and ranch. I know that we have a few agents that do farm and ranch. There were a couple of changes on farm and ranch. So scrolling down, again, you're going to see it's pretty much all related to compensation. So this one, they do have a notice. The terms of the contract for the sale of property will control which improvements, accessories, crops, or reservations will be included. They're striking the notice from this section and they moved it up. Broker's compensation, again, they're striking out everything in the red and they're streamlining it to look just like it does in the 1101 and the 1102 listing forms. So, oops, sorry guys. So on this one, if there's compensation to another broker, you're going to use A, right? Your percentage, your sales price. B is if there's a variable rate. And then down here on section B, so it's if there is no other compensation. Same note they've put in here, seller paying buyer's expenses. In addition to paying the above broker's fees, a buyer may request to contribute. References paragraph 11F for the authority regarding those contributions. The rest is just paragraph numbers. Number 8, they've taken out cooperation with other brokers and left it reserved for use. Once again, seller does or does not authorize broker to share with other brokers and prospective buyers about these contributions. Special provisions, they removed part of that, moved it down. Additional notices, they have done the striking on the broker's compensation being fixed because they've added that into the compensation section. Again, all these numbers have changed. And another thing that I forgot about, you'll see now pretty much all forms are saying broker's associate signature. And now instead of putting sales agent, they're just referring to sales agents as the broker's associate, right? Because a broker will have broker into their title, not broker's associate. So to clarify what that means is technically I now have my broker's license. I am a broker. Previously, they would refer to people like me as a broker's associate if they were remaining under a different brokerage instead of starting their own. So that is the clarification there. There is also going to be a form related to any of these statements for compensation that needs to be filled out with the listing agreement. Find that one really quick because it's the perfect time to talk about it. I'm looking for 1412. Okay.
In 1/3 of a mile, turn left.
Seller's authorization to disclose, used to say release, now they're saying disclose and advertise certain information. So for example, if your seller wants you to advertise that the property is buyer friendly or willing to contribute buyer's compensation, right? Wants you to market it on your website or on a flyer or at an open house, you want to have this form filled out and signed. Everything that you do needs to be in writing. So on this form, you'll see that they have concerning the property you put the property address in there. You're removing all of the broker seller information. They've just stuck with property. This is saying seller authorizes broker to disclose and advertise the following information concerning the property, prospective buyers, other brokers, and on MLS services. We can't put compensation on MLS anymore, right? So you can put a comment on there that they'll consider contributing towards buyer's expenses that you can put on the MLS. But any fees or numbers or dollars amounts, you don't put those on the MLS. Use this form, make a flyer. You can make a separate landing page. I know that they're stating that you can put those on a website. The thing is if you have an IDX website, you're not going to be able to do that. And I would not recommend doing it anyway because it's going to be a lot of manual work. I would just work with the flyers. And the other thing that we need to get used to doing is calling agents and asking them what their sellers are willing to contribute. Or you can have a form that's filled out, and we'll get to that one in a minute, that you can just have it ready to say, this is what my seller is willing to do. And that way you don't have to have 1,000 conversations with the same information. Now, at this point, I will open it up to questions on these last few forms. So let me see.
Good morning. I have a question. Good afternoon. So I can do a flyer, post it on Facebook, with the address of the house and say seller is willing to do buyer compensation and put it in there?
Yes,
That will
Okay.
work.
that will
Okay.
work. Make sure when
Or
you're
I
doing
can-
that, though.
Or the same flyer, I can go ahead and, for example, put it on the Encore chat, and that way everybody knows, or I can send it to other agents and send them a text. Okay, perfect.
Yes.
Thank
Just
you.
make sure that you have this form
Yeah.
filled out, allowing you the permission to do so.
Okay. Thank you.
You're welcome.
I think that's gonna solve a lot of issues or questions.
It is. And it's just a matter of we're going to have to get used to doing business in a little different way, right? And we're going to have to communicate a little bit more. I actually think it's a good thing. I think that we should be having a conversation before we're writing a contract or before we're doing an offer. That's just my opinion. All right, I did see some questions here in the chat, so let me scroll up here. When are the changes going to start? So these forms are live on Zip Forms now. They've already made the changes. You can no longer access the old forms. So the changes are well into effect right now. There are a few different things that are going to be required as we get into these different forms. I will explain, especially when it comes to amendments. There are some stipulations for existing agreements and amendments to those. August 17th is the date that everything has to be effective according to the lawsuit. Ravi and I already had a conversation about these changes and when to begin them. We're going to start using these forms now. We need to start getting in the habit of using these forms and following these procedures so that before it becomes a factual in law set in stone agreement, we're already there, we're already in the habit, we're already prepared, and we're running instead of stumbling.
And I don't think you can use the old forms, because yesterday I submitted an offer and I used some of the new forms already
Yes,
in there.
yes, they're already there. They're already showing. If you pulled anything Monday morning, they were not updated because I got into Zip Forms to be able to, I was looking for the forms specifically to check to make sure that they were updated and they were not. So if you wrote something Monday morning, you might have wrote it on an old form. Don't worry, there's an amendment for that. And the other thing is, if you have a listing agreement in place or a buyer's rep in place and it is not under contract before the 17th, you're going to have to do an amendment. And we'll talk about that when we get to the amendment form. So let me see, item line B could be if the buyer comes directly to you as the listing agent. Oh, sorry. Are you referring to the variable rate, David? I believe that's what he's saying with item line B.
It's me, Alma. It shows
Oh,
it
sorry.
shows David Cooper because I'm on his computer. But yes, when you have a variable rate, if the buyer comes to you directly and doesn't want to be represented, or else doesn't want to pay a commission, that's why they're coming directly to you as a listing agent.
Correct. But again, that section, you're agreeing to that up front before you list it. So
No,
you're
I understand that, but I'm talking
Okay.
about if a buyer comes to you as a listing agent, and they say, I don't want to be represented. I just want, work with the listing agent directly or with the seller directly, then how do we handle that?
So I'm going to refer that question to Ravi because ultimately that's his decision.
Have to unmute.
You're gonna have to say it again.
I just hopped on. I don't know if you guys can hear me. I think what she's asking if it's a variable rate, but you already have a listing agreement with how much the seller is going to pay you. So there's no other discussion, right?
But I'm saying if the buyer comes to me as I'm listing the property and I've got my contract with my seller, but the buyer comes and says, I want to buy directly from you. So, I mean, you're going to be putting more work is if you're going to be drawing up the contract for the buyer but yet he doesn't want to pay you, we also need to be aware or discuss how we're going to handle situations like that.
Well, again, in that circumstance, it's whatever your listing agreement says, right? But you were asking what additional steps would be required, which is a Ravi question.
Same steps that you now, I mean, I know agents do end up where they have.
We can't hear you, Robbie.
Oh, you can't hear me at all?
There you go. Now.
Oh, too closer to the computer. No, you have to handle it the same way you're handling it right now. I know that a lot of agents, they do get the listing and they get the buyer directly. There's no additional form that I'm aware of. Of course, you have to let the buyer know that they are representing the seller and get that in writing.
Yeah, but who's going to prepare the offer?
You'll have to prepare the offer.
That's what I'm saying. So now I'm incurring doing it more work for that buyer and they're not paying. So I guess you just turn them down, or what do you do? Because if they're not going to pay you and the seller, you already have a contract with the seller. And in essence, you're going to be doing intermediary but you're only getting paid once. So that's something that was brought up in that other class too, is that's something that needs to be discussed with the broker, how we're going to handle those situations.
Well, you would have to ask for compensation. They don't want to pay, you still have to, do everything in the best interest of the seller to help sell the property. What else can you do?
So I just hopped on a little bit later. Am I understanding this correct? So for me, nothing is really changing. You're still negotiating with the seller. You still can offer some sort of compensation to a buyer's agent. You just can't do it through MLS. So you can do it on your website. You can put it on your sign out front. So there's ways to do it. So you still should be negotiating just like you were normally doing. You're not going to just say, well, I'm just going to negotiate for myself. And help me, Ravi, is that what you're wanting them to do, to still do it the same way? You're still negotiating. And you have to be able to advocate to your seller, look, it's at your best interest so that we can sell this property, to offer something. You just can't put it in MLS. That's the rule.
Yeah. And still, I would recommend to ask for buyers' compensation, discuss that with the seller, because that would just be the easier way, to get it done. Just like we've been doing it. It just can't be on the MLS, like Vicky said.
Ravi, I would like to know, how do you talk to your buyer about this?
Well, Jennifer, have you gone through?
We'll get into that in a little bit. I want to stay focused on this section of the forms really quickly.
I have a quick question. So when we're doing a listing agreement and we're charging a certain percentage and the seller is willing to do a buyer's compensation, let's say, if I can say a number, let's say we're charging 4% and 2% for buyer's compensation. And there's no buyer's agent. Do you still keep the 4%, or because you don't have a buyer's agent, you only charge them half? Is the broker fee still?
You keep your 4%. What are you keep the whole percent, girl.
Okay.
Right. You just have to make sure that the buyer understands that you are not representing them.
Yeah.
You are only representing the seller, and you will not have a buyer's rep in place.
Yeah, because if the seller comes back and say, well, since there was no other agent involved, now I'm only paying you 2%, because the other 2% was to compensate the buyer's agent.
Right. And they can do that. Like I said, until you actually are under contract means that's legally binding and they agreed to pay that. Until that moment, he can come back and renegotiate. Okay. I don't want to get off into the weeds, guys. I just was trying to answer some of these questions. I know that you have a ton of questions. There's a lot of things that are changing. It's very confusing. I'm trying to stay at this moment relevant to the listing agreements, okay? So hang on, I saw another question. One moment, you guys. If you agree with your, oops, it just scrolled down. If you agree with your buyer percentage and the seller offers a flat fee, can you get both? So yeah, the way that this is gonna work is now you are going to have your buyer's rep sign before you ever show a property. That is part of the agreement of the settlement. And again, that doesn't take place until August, but we are implementing these practices now so that we're getting used to this. So when you sit down with the prospective buyer, right, at that time they're going to be a customer, but we're wanting to convert them to a client, we're going to have these discussions and we're going to talk about it. So we're going to get into, there's a short form now, and there's the long form with a few changes, okay? When you're having these conversations, again, we need to remember that compensation has always been negotiable. You can't say, I always charge this, and this is what we do in this brokerage, because we don't. Everything is a case-by-case basis. So those are the discussions that you're going to have up front. If your buyer agrees that, hey, I'm willing to pay you 3%, and you find a house that has the seller's compensation of 2.5, then yes, you can go ahead and charge them that difference, right? Again, it's what we agreed to. And if there is compensation offered and the buyer wants to reduce what they're offering, can they do that? Yes, they can. Do you have to agree? No. But if you want to move forward, you might want to. But you can, it's a discussion, it's a negotiation. Why is it reserved? It could still, so the reserved paragraph is they're holding a place in case they need to insert additional language later. And the buyer's rep agreement, we will get into those. So again, I just wanted to focus on the listing agreements first. Now we're going to look, let me close this chat. Now we're going to look at Form 1402. And again, guys, I did not have time between taking these courses. I took one Saturday, I took one this morning to do a formal presentation. I just wanted to make sure that we got you as much information as possible. I do plan to go through and put something together that's a little bit more easy to understand and that flows a little bit better. But right now, to be honest, we're kind of flying by the seat of our pants because everything is changing so rapidly. And like again, from Friday to Saturday, information changed. From Saturday to when I took the course today, things had already changed. So there are a lot of things that are continuing to evolve. 1402, named exclusive addendums. So if seller has a direct buyer they've been talking to, that's when we would use this form. So if you have a seller that says, hey, I've been talking to my brother-in-law's neighbor and they're thinking about buying my home and they said they were interested, and I just want to make sure that if we go under agreement and then they come back and say they want to buy the house, I don't have to pay you the commission. This is where this form would come into play. And on here, named exclusion means the following person. It's not my brother-in-law's neighbor. It is their first and their last name. And again, you're answering all of these questions about the percentages of the sales price. If it's a exclusive right to sell, a percentage of the rent, if it's an exclusive right to lease. And then again, it changed from broker's company to broker's printed name. So Ravi goes in here under broker, not Encore 5 Properties. And then seller or landlord is changed to owner's printed name. Okay, exclusive agency addendum to the listing. This one, addendum to listing agreement between the undersigned parties concerning the property at. So this means that they have an excluded prospect, the naming of the excluded prospects, public marketing. This says the owner can publicly market with signs, newspapers, internet, etc. So again, this is if you want to do an addendum to that listing and they wanted to add somebody later. Here's your amendment to the listing agreement. So on here, this is where it talks about your 1101, which is your residential exclusive right to sell, and your 1201, which is your farm and ranch. This is if you are going to make a change to the compensation, whether it's percentage of sales price, flat fee, or if you have a variable rate that's going in here. And again, compensation paid to the other broker is as follows. So if you're going to get 5% from the seller and you're going to give half to the other broker, then that 2.5% goes here. And then again, broker's compensation or the sharing of compensation between brokers is not set by law or fixed, controlled, recommended. This wording was already in these contracts. It was just in a different place, but here they've added it specifically to this amendment to the listing. All right, this one we already talked about. So if you have a seller that says, hey, I want you to advertise buyer friendly, willing to offer buyer's compensation, willing to do concessions, I give you permission to put a sign directly in front of my property that says I am buyer friendly. All of those things you're going to want in writing and signed. Representation disclosure. Let me find my notes really quick. Okay. So these they're stating you can use these ones if you are at an open house. So this is essentially you are letting whoever walks in the door know that you are there and you represent the seller. So that's what this is stating. This is the broker's name. This is the broker's associate. So if I, Jennifer, have decided to hold an open house, I'm going to put my name here. And this states that I am representing the seller. Okay, this is where you put the seller's name. And anybody that comes in the open house, you want to make sure that it's full disclosure. They understand that you represent the seller, you are working on behalf of the seller's best interest, and they should not disclose confidential information to you. And yes, you should get one of these signed by them. That is the recommendation. Okay, buyer's rep agreement long form. As I mentioned, there's a long form, the existing one that they've made changes to, and there's a short form. So we're going to go over the long form first. So here you see they've specified a little bit more about what market area is, because there were a lot of people that were just putting Texas in here. So when you're doing market area, so for example, if you have clients that are looking in Cameron County and Hidalgo County both, and before they make a decision, they want to see properties in both respective areas, put both counties in here. If you have a client that is focused solely on a specific zip code, you can put that in here. If you have somebody that says, hey, I just want you to assist me with this specific property, you can put the property address in here. Okay, the main point is for market area, we want specificity. The term, and they just changed the wording from commences to begins. So it's going to begin on X date and it's going to end on X date. Section 7 is broker's compensation. And so again, it's talking about what the compensation is for leases and for purchases and for leases. And it is now spelled out in one section. Talks about what the source of compensation is, earned and payable. A lot of this language, it was already addressed, but here you have the notice regarding bonuses and other compensation. Previously, you could get a bonus and it didn't necessarily have to be disclosed to the buyer. Now you need to have their authorization to do so. And you can use the 1505 in order to amend. We'll get to that in just a little bit. You have your protection period in place here. You still have the section where you can enter the days. Oops, sorry, I was trying to get it to scroll down. So here where it says amounts payable to broker, this is actually something that I learned in the class. This is where the broker's physical office is, not where the property is located. So that was interesting to know. I've been doing it all this time and didn't have that correct information. Sometimes education is really, really good for you. In intermediary status, they've just made minor changes, paragraph numbers and references. This one, they've taken out everything related to the broker's fees. Everything's moved to paragraph 7. Just moved around the numbers a little bit. And then here they got a little bit more specific about requests to wire funds. And again, this is just stating down here, broker will not send client any electronic communication with instructions or wire funds to provide their personal information. So broker's printed name, Ravi, not Encore. Broker's associate, that would be you. Now, let's go to the short form really quickly. And again, on that one, I think it's at the very end of this because it's a new form. Give me 1 second, guys. I gotta find it. Here it is. So 1507 is the new buyer's rep short form. On this one, you will see that you now have a section where you can offer just showing services and charge them a set dollar amount. One thing that Ravi and I talked about before we did this, and then I'm going to let him talk a little bit more about showing services and what his expectations are there, is that if you agree to be a showing agent and you're just going to collect a fee to go show them properties, you're not going to have any fiduciary responsibilities to them, then if they choose that they want to work with you and they say, okay, I really like this property, I want you to write me up a contract, you need to switch to the long form buyer's rep. And one of the main reasons for that is that in this short form, it does not have any sort of language related to liability or indemnity. Related to the fees, how that's going to take place, how you're going to get the money to Ravi, what Ravi's going to charge for that. I'm going to now refer it back over to Ravi and he can discuss that part.
Yes, regarding the fees for showing, I will send everybody an email about that, on what the encore fee will be. Let me just think, and then I can decide, let you know. Is that fine?
Yeah,
Jen?
that's fine. Are you planning to set a designated amount? Are you planning to set a cap? Is that to be determined?
Yeah, to be determined. It's just gonna be a small fee, but I'll send an email to everybody regarding that, because that's just something for, showing properties. But the amount won't be that much. It'll just be minimum. And regarding the other broker's compensation, well, you're gonna be paying.
So if you choose to do showing services, again, paragraph 6, 7, and 8, they don't apply, right? So you're not going to put anything for compensation because you are literally at that moment a showing agent. It's just like somebody contracted you on Show Amy and all you're doing is opening a door. One of the reasons why they decided to do this, though, was because they realized that Zillow has a touring service that's available. So they're trying to give us agents the opportunity to get in front of buyers that are hesitant about working with a buyer's agent or don't necessarily think that they want those services. It's your opportunity to show them that they do actually want those services and that we do earn every penny of what we do with our knowledge and our experience. So that is 1507. Let me go back to 1505. So this is the amendment to buyer tenant representation agreement. If you have buyer tenant agreements that were written before Monday, yesterday, 6/24. You are going to need to amend them if you're not under contract by 8/17. So for every one of these that you have, if you're not under contract before that date, and I would recommend that we actually set that date to August 1st so that we're compliant, we're gonna have to have one of these amendments done. So you're gonna have your notice on here. This is your 1507, so this is your short form, right? Whether it was full services or showing services. You're gonna wanna make sure that they are fully understanding to move forward, that there's going to be a percentage that's paid, whether it's a purchase or a lease. And you're switching them from full service, or excuse me, showing services to full services. That will amend that. Same thing applies if you have the long form. You're still going to do an amendment because it's addressing the changes to the forms that have taken place since they signed. Do we have any questions related to these? I know we covered a lot of stuff, but I don't want to wait until the very end and try to answer relevant questions either. No? Okay. So,
I have a question, Jennifer.
yes, go ahead.
Regarding the form that you mentioned about the open house disclosure of representation, or what's the name of that one? The one that you said if we have, on that one, I would like a little bit more clarification on that. If I have a listing and I do an open house and I present that to unrepresented buyers, I'm not, if they want to buy like another home, I'm not able to pick up that lead.
No, you could. At this point, this is letting them know the minute that they walk in the door, you represent the seller and they should not disclose confidential information to you. Because, you know, as buyers walk through a property, they have a tendency to talk, right? And they might disclose some personal information that they might not want the seller to know, but they don't realize all the time that whoever's in that place is actually representing the seller. So this is making sure that they understand from the moment they walk in the door that the person in front of them represents the seller and not them. And that the confidentiality, they should not disclose confidential information.
Okay, but if they would want to, let's say, work with you and buy another property, they're still able to do that.
Yes. And then
Okay.
that would work for it. You would work with them and tell them, hey, I'm able to assist you. You talk about the buyer's representation agreement, you talk about compensation and all the stuff.
Mhm.
All right. Residential leasing and property management agreement.
I have a question.
Go ahead.
Yes. If, let's say I'm in the listing agent, somebody wants to buy the house, they come in and they start making questions about the property or why they are selling. So I just stay quiet?
No, you can talk about the property.
Okay,
Yes, you can,
What
but
is the
they need to
information that
make
I-
sure that they understand you represent the seller
okay,
and that any confidential information that they disclose could be presented to the seller. They just need to know that you don't work for them. So they might want to and not share certain information with you.
okay. They shouldn't share their information with me. I just tell about the details and, because you know how they like, and why they're selling, are they moving? So I don't answer those questions like very in detail. Or do I?
It could be a pertinent fact, right? So if they're moving and it's going to be under a relocation, the
Okay.
relocation does have actual repercussions to the transaction, right? So it is a fact that you can share with them, because if you're working with a relocation company, they just need to understand that, yes, the seller is relocating, they have a relocation company involved, but you don't have to disclose anything about why the seller is selling.
Okay. Thank you.
Sorry, just I think just not really interrupt, but I think just to add on that, just to make sure that I'm really understanding everything. That form in itself is just mainly to tell that prospect that's coming in, like, hey, I am representing the seller, just so you're aware, so you don't overshare any information with me that would ultimately affect your offer or however you would like to go ahead and proceed with this home.
Exactly.
Okay.
And it's a protection to us, right? So that they can't say, well, they didn't let me know and I didn't realize, and then you've got a big old ugly mess on your hands. So
Well-
it's making sure that they fully understand when they walk in the door, who's being represented by that agent in front of them.
Yes, ma'am.
Well-
Okay, perfect.
I've been using that form, and I don't know if it's okay. Even when I submit an offer, I send it to the listing agent and I represent the buyer. I always let the other party know who I represent.
Okay. That's fine. And really quick, I'm glad that you said that because it did come up in one of these courses that what if a listing agent asks you for a copy of your buyer's rep? We do not have to disclose those. All we have to do is answer their question, do you represent this buyer? Yes, I do. They don't need to see a copy of that form because it has confidential information.
Would that be the same thing for a listing agreement if the buyer's agent is asking to see it?
Correct.
Okay.
So what really matters, and we're going to get to those in a minute because there is the agreement between brokers. The agreement between brokers is actually your new MLS. This is where your compensation agreements are going to come in line and you're going to make sure that it's signed. So as a buyer's agent, and I'm going to submit an offer and I already know that they've told me that the seller is willing to pay X%. I'm gonna make sure that I have that filled out on that form and I send it in to get it signed by the seller because that's the form that's gonna go to title so that title knows who's getting paid what and by whom. But we'll get to that in a moment. So the residential leasing and property management agreement, nobody really does property management in here that I'm aware of. Ravi doesn't particularly allow that. So there were some things that changed. If for some reason you would use this, just know, I just saw something there, right there. So the compensation section, they've changed a lot of stuff on that one. And I'm going to move on because, like I said, we don't really use that. Again, there was a change to the Texas Realtors ICA. Ravi has his own independent contractor agreement. So this one doesn't matter, but I'm just letting you know that this was something that was changed as well. This one. Registration has been removed. It is now the compensation agreement between broker and owner, year number 2401. This one is if you have a for sale by owner, for example, or if you have a builder that doesn't have the house listed, but you have a buyer that wants to purchase. You would use this form so that you're going to have the property address in here. You're going to have the asking price, all of the information. You're going to register that buyer with the owner. And this is the form that will be your agreement for you to get paid, right? This is your compensation for making that sale. This is the new MLS. So compensation agreement between brokers. So you're going to have your listing broker, your cooperating broker, you're going to have the property address. And then again, if you want to have the legal description, you can attach that as an exhibit. You're going to register that with the form, right? So your prospect, they remove that and change it to client, which is good because that confused a lot of people, honestly. And then they've changed the owner here. So it's taking out the paragraph about the listing principal broker not being obligated. It has all of this fees earned when payable. This is for a sale, percentage or flat fee, lease, percentage or flat fee. And then they've removed this whole section where it was all stated about renewals and subsequent sales and all kinds of other information. So again, this is what is going to let the title company know who is getting paid and what. And then they did make a change to the referral agreement between brokers. This is Texas Form 2405. Again, sales agent was changed to broker's associate. This one, they've just deleted some terminology and added some terminology relating to the broker's fee. This is referring to transactions. Referring broker will be entitled to the fees stated in this agreement. And then you have your signature page, and they removed all this additional section. So they essentially just tightened up the signing section. So we already talked about 1507. This is your addendum regarding broker's fees. So if for some reason something changes, this is where you would go in and do the addendum. And then here is your amendment to the representation agreement. So yeah, for all agreements, for listing agreements, for buyer tenant agreements. Let me look at the chat. Yes, your broker still needs to issue the CDA because that is the authorization table fund to pay you at closing. So you still would need that disbursement authorization. I know this was a lot of information in a very short time frame. I get that your mind is still processing half of what I said and not process the rest of it. So we definitely recommend, as you think about the information, as you go and look at the forms yourselves, as questions come up, do not hesitate to reach out to us because we are all learning as we go. Do we have any other questions?
I have a question.
Okay, go ahead.
Okay, so you said that we have to advise our sellers facts of what commission's been paid. Is it going to be in the MLS how much the buyer's agents receive in commission?
No. So
Well, how
what
can we?
you're gonna advise them on concessions. And it's not gonna specify if concessions were used towards compensation, but it is a material fact of what's happening in the neighborhood related to what's being offered, right?
But how are we going to know that fact? How do we know the facts of
Because
what's happening?
when a property closes, it shows on the MLS where it closed, right? The date, it shows the sales price, and there's a section that it also shows the concessions that were paid out.
Okay, that was my that was my question. Is it show in the on the form? It does. Okay.
It does. It shows.
Okay.
Let me see if I can find one.
Will include, it could be buyer's closing costs mixed with the commission. You just won't know how it was divided, right?
Correct. You won't know how it was divided, but it is a good information to share with your seller. So for example, I had a listing presentation last week. And in that presentation, the discussion came up that they did not want to work with FHA or VA buyers. And one thing that you can very easily do is you can show them what type of financing is being used. Hang on, I'm trying to log
No,
in.
I know. I understand that.
The other thing that you can do is you can say, you know, X amount of properties in this area had concessions that were offered. And now there were 2 properties in the neighborhood that I was doing the listing agreement at, where Redfin, for example, showed the value, estimated value of their home was $340,000. And they asked me why my number was less than that. And so I told them the reason that my number is less than that is because Redfin doesn't know that concessions were given on those 2 transactions. So these are all discussions that should be taking place, right? And we should know these things when we're going into a listing appointment. We should know how many of the properties are financed versus cash. because your client could ask you this question, but you want to be the local expert. You want to be able to inform them to the best of your ability, and doing so means that you're looking up these sales before you go and sit with them.
So, okay, so you said that the compensation is gonna have the sales price plus the commission?
It
So
will
it-
have concession. Compensation is no longer going to be on the MLS as of, I believe, for our GMAR board, they're trying to do it by August 15th, I think was the last date that I heard. That could change because it was a moving target, but the goal is to have it a couple of days before the 17th when it actually goes into effect.
So it's gonna say compensation paid, and it's gonna be the sales price plus the whatever the real estate consideration or whatever you're calling it.
No, it will show your sales price, right? What it sold for. And if there
Uh-huh.
was a concession, it will show the amount of the concession, as long as the agent puts that information in.
But those concessions could pay for closing costs, they could pay for commission and so
Okay.
on. They're just not gonna be broken down. Okay, so
Okay.
much commission, so much.
I
and
got
so
it.
Right,
on.
but
Okay.
again, when you're in a listing appointment, right, and you're having this because it's a discussion. So you are informing them of what is going on in their area. And you
Absolutely, and I
say,
do that. I
yes,
do that.
we've
I tell
had,
them what
yeah,
the area is doing, if it's FHA or conventional. I tell my clients that.
yes, and that's what you want. And you can tell them, FYI, there have been 5 sales in this area, whether it's a 1-mile radius or it's in their neighborhood. There's been 5 sales, and of those 5 sales in the last 3 months, 4 of them paid out concessions. That is a material fact about that market area that they need to know before making a decision.
Perfect.
I have a question.
Yes.
There are several dates that have been thrown around. One was in July at first, and now you're saying August. Can you clarify those dates now?
I honestly don't know what the July date was.
Well, that was at the beginning, when the lawsuit was settled and they said things would change in July, but now I'm hearing August.
Well, it might have been that they were giving some of these associations, right? And these state associations and these local associations time to develop whatever needed to be developed. So the forms and the form changes that needed to happen, they might have given that time frame of July 1st. But Texas Realtors decided that they were going to release these forms and make them effective June 24th. So each state can do whatever they want to do for their state, for their association.
But when is the legal date that things have to be done a certain way? Now it's August? You
It's
said
August 17th.
Okay, thank you.
You're welcome. But again, we are choosing to move forward and use these forms now. Well, you have to use them because they're on zip forms, but
I
we're
understand.
to get in the habit of following these practices. That's the best way to put it. We're going to follow these practices now before August 17th. So we are in the correct habit and we are doing the right thing.
If you don't mind me interrupting. So I have access to the Austin MLS, and it's called Unlock MLS, and I'm reading an email right now. So their changes are going in August 13th. So it says legal update August 13th deadline for MLS rules and business changes. I think really it just depends on the board. But I think preferably it probably will be in August. Exact date, I think it probably will differ on the board itself.
Okay, so if we're talking about when the compensation on MLS changes, I had heard that GMAR was looking at doing it on the 15th of August. I don't know if that has changed. That was the last conversation I was privy to in our last education meeting, but that was several weeks ago. So that target date could have changed, but that's just where compensation goes away on the MLS. These forms obviously have already been implemented and they're already out there. And I'm glad that you mentioned Austin, because I was informed today that Austin created their own forms. And it is up to the broker's discretion if they want to allow their agents to use Austin's forms. You have to be a member of Austin MLS in order to have access to these forms. But that's something that you might want to address with your Austin agents, Ravi. I just remembered that. Thank you, Alejandro.
Well, so what is GMAR?
It's the Greater McAllen Association of Realtors.
Okay, because a lot of us some of us that I see here, we're in the Dallas area. So
Gotcha.
we're in a different MLS too, so.
Yes, and so they might have a different target date,
Okay.
but again, it's got to be done by August 17th according to the lawsuit terms.
Okay,
I just want everybody to start working on it, you know, as soon as possible. Any new contracts, any new listings, they have to use the new forms, correct?
Yes.
Right. And,
Yeah, they don't have access. If you have something saved on your computer, I highly suggest you delete it.
So it would be a good idea also to start working on your amendments. It's already going to be July 1st and probably within the next 30 days, 40 days. And if your property is not moving, don't wait till the last minute. A lot of agents wait till the last minute and then they're like, okay, what do I need to do? What form do I need to fill out? There's that amendment to the listing agreement, right? That you showed us.
Yes.
And I'm going to share the video link with everyone so you can watch the video again and look at that listing amendment. And I would recommend to just start working on it now and just get it out of the way. You don't have to wait till the very end. Because after that deadline date, you know, the seller can say, hey, you know, these changes have implemented, so I don't have to compensate. There's a lot of things that have happened behind the scenes that agents are not aware of, that only I listen to from one of our Encore agents, what they go through, you know, with sellers.
Yeah, and
So-
really quick, I just remembered one other thing that is vitally important. If you have a client that says they only want to see properties that the seller is offering compensation, you need to put that in the special provisions of your listing agreement to protect you. Because otherwise, if you're not showing these properties, it could be considered steering. So you need to protect yourself. If they tell you that, put it in writing, get them to sign it.
And they say they're not comfortable, well, then you can't show them the property. You understand that? You have to protect yourself and of course, Encore and all the agents. So our E&O stays, you know.
Low. I joined a little bit late. I apologize. I don't know if you already touched on this or not. But I am about to send over an offer right now and I'm making them sign obviously the buyer's rep and all of that. Would you prefer me to use the new buyer's rep starting today or because
Are you on Zip Forms?
Yes, ma'am.
It's already the new form. It's already uploaded.
Well, I did it today and it's still the same regular other one.
It shouldn't be.
Mhm. I don't know. I don't know if there's something that I don't know how to update it, but I just did it right now. Like I just finished. Like that's why I just joined.
Try deleting it and adding it again because it should be updated. The only thing I can think of is if you already had that open for the last couple of days, maybe that.
No, I just created the file.
Okay, well then, why don't we do this? All agents go and look in their Zip Forms and make sure that they have the updated forms. I know for a fact mine does. Mine changed yesterday afternoon.
But is this for Texas Realtors or TREC? The TREC forms or TR?
All of these ones that we went over are the Texas Realtors.
Yeah, no, yeah, that's what I'm on, and it's still the same one.
I had mine saved and it automatically gave me the new one. Didn't give me the option for the old one.
And it should, that's the way it should work. So try logging out or try deleting that form and re-adding it. If it doesn't update, contact Zip Form support because something isn't right.
Okay, will do. Thank you.
Form. It says, yeah, it says June 2024. It's already updated. Yeah, it shouldn't show you the old forms. Oh, also another thing, I do have several agents that do collect, you know, transaction fees from the buyer right now, and they're helping the buyer. It is written in the buyer's rep agreement. It is very important that it's written in the buyer's rep agreement because now with the new changes anyway, you're going to be asking for compensation in terms of a percentage or transaction fee. But I've had several agents. One of them, for example, Alejandro, you know, he collects a transaction fee from the buyer. And it's in the buyer's rep agreement. The title company usually likes to ask for a copy to make sure we're not charging the client without their consent, but it's in there and the client, of course, signed it and agreed to it.
No, yeah,
And
I
I-
actually just went over it and it's the same thing. So I just saw it. I guess I just didn't really like I reviewed it, but the only really change I think is just section 7, subsection A, where it says broker's fees. There's just now a little box. And I just put the 2% there. And then regarding the transaction fee, yeah, I went ahead and just put it in the special provisions as well, as always. So nothing really changed of how I really filled it out. Just I
No,
guess
it's
that
just more
box.
pronounced so that the buyer can see, right? Or even on the listing agreement, they have
Because
that box around there.
when I just explained the contracts right now, I explained obviously the buyer's right, but I also went ahead and explained the semi last page in the 1 of 4, and there it says that the listing agent will pay, you know. So I think that the vocab to that is saying that my commission, that's how I explained it to them. It's like my commission is coming directly from the sale. I'm not charging you an extra percentage. Therefore, you know, that's per the last section of the contract where the broker information is at.
Well, no, but it specifies that if the broker does, or excuse me, if the seller doesn't pay, that they are responsible for paying you.
No, I told them that, but just
Okay.
reading that last section.
Okay.
Mhm.
Any showings that you do where you're just doing a showing fee and charging a showing fee to show homes, make sure all the checks are payable to Encore. Checks should not go to the agents directly. Unless it's been authorized, which it's just gonna be more work. So I would just recommend that it just comes payable to Encore and then I'll pay you from there. Okay. Just like the same way for referrals and leases. Oh, also really quick on the leases, I did send a message, I believe, to everybody. I'm not sure, I'll check and I'll send you an email that Encore we can collect, Encore can collect a fee via Zelle from your clients, from the landlord, basically, even if I have to pay out another brokerage, I have to pay you. So I can collect it via Zelle or Cash App. Okay, I offer that because it just speeds up the process and you don't have to wait for the client to pick up the check from them and waste time. And I just want to save you guys time. Yeah.
Okay. Doesn't look like we have any other questions.
Anything else? No. Everybody excited?
No.
So I don't have a question, but I do just kind of want to follow up on like what Alma was saying. When is it going to be effective for the Dallas agents on MLS? I just got on MLS online. It says that it will be effective in July, but it doesn't have a specific date.
All righty, thank you.
Oh, that must be where you were seeing July, because I haven't seen anything for July.
That was in the email that I got from the president of NAR a while back, talking about the lawsuit. But it's all right, no worries. I was just curious.
No problem. There's been lots of things changing, so it is hard to keep track of what's what. All right, well, I thank you all for being here.
Yes,
Thank you.
so much.
Thank you.
Thank you for hosting the class.
You're welcome. I will try to get something else that's a little bit more structured and easier to understand for you soon.
All right. Thank you.
Thank you. All set, Robbie?
Yes, also.
Okay. Have a great day, guys.
Bye-bye.